as part of a ruling that upheld President Donald Trump's travel ban. The forcible relocation of U.S. citizens to concentration camps solely and explicitly on the basis of race is objectively unlawful and outside the scope of presidential authority, Chief Justice Roberts wrote in the majority opinion on Trump's case. During World War II, President Franklin Roosevelt issued an executive order that forced more than 100,000 people of Japanese descent into detention camps. In Korematsu v. United States, a man named Fred Korematsu, a Japanese American, refused to comply with the order, and the case made it all the way to the High Court. On December 18, 1944, the Supreme Court upheld Roosevelt's order and ruled it was a military necessity to detain Japanese people and that the decision was not based on race. The Korematsu case was overruled on Tuesday. Today, the court takes the important step of finally overruling Korematsu, Justice Sonia Sotomayor noted. This formal repudiation of a shameful precedent is laudable and long overdue. But it does not make the majority's decision here acceptable or right. Roberts called the Korematsu case gravely wrong the day it was decided. Share this article. But Sotomayor, in her dissenting opinion, also argued the court was redeploying the same dangerous logic underlying Korematsu in upholding Trump's travel ban. She called the ban a discriminatory policy motivated by animosity toward a disfavored group that is being justified via a superficial claim of national security. Roberts disagreed with her, arguing it's wholly inept to liken that morally repugnant order to a facially neutral policy denying certain foreign nationals the privilege of admission. In Tuesday's 5-4 decision, the Supreme Court ruled the president has broad authority to regulate immigration despite concerns his travel ban unfairly targets Muslim countries. Roberts wrote that Trump's travel ban proclamation, issued shortly after his inauguration, was expressly premised on legitimate purposes, preventing entry of nationals who cannot be adequately vetted and inducing other nations to improve their practices. The text says nothing about religion, he added. Writing for himself and Justices Samuel Alito, Neil Gorsuch and Clarence Thomas, Roberts also noted that the Trump travel ban did not apply to Iraq, one of the largest predominantly Muslim countries in the region. The policy covers just 8% of the world's Muslim population, he wrote, and is limited to countries that were previously designated by Congress or prior administrations as posing national security risks. The case decided Tuesday signals that much of Trump's immigration policy, stemming from his campaign promise to tightly control the nation's borders, is passing key legal tests. The third and final iteration of the travel ban policy applied to foreign nations from Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. The court determined that the administration set forth a sufficient national security justification to survive a review of whether there was a rational basis for Trump's travel ban. But the 5-justice majority cautioned, "We express no view on the soundness of the policy. We simply hold today that plaintiffs have not demonstrated a likelihood of success on the merits of their constitutional claim."